Hello, everyone, and welcome to Overtime. My name is Nicholas Lamar Soutter. My voice is still, I'm going to try to push through a little bit on this, but my voice is still a little burnt there, but I hope everyone else is doing well. This week in the news, Tokyo has now actually for the first time admitted that they're considering canceling the Olympics and that is on the table. Bernie Madoff died in prison, and hundreds of CEOs and more than 110 corporations took out a full 2 pages or ad that covered 2 pages in the New York Times and Washington Post saying, quote, "For American democracy to work for any of us, we must ensure that it works for all of us." Now, there's been a few other, I think rather than do sort of our normal rundown, one of the things we're going to do is cover some legal aspects. We have Nate the lawyer with us. Nate, how are you? Nate is my favorite guest. He's quiet. I can just keep talking. Let me tell you Nate's opinions. I'm going to tell you all Nate's opinions because apparently he's muted, so I can say whatever I like. And no, you know what? It may be on my end. You know what? I think let's try resetting your.
Mike,
there you go. I think it was muted here. I think your shield went up prematurely, so there it is. Good.
You can hear me now.
Yes, sir.
Can you hear me?
Yes,
all right. Yes. Woo! What's going on, guys?
Good to see you.
Yes, no,
Good
we got
to
a lot
see you.
to talk
It's been too
about.
long. Yes. Oh my God.
It's been amazing, man. It's been amazing. It's just funny how time flies. You wonder what you're here today. What is he gone tomorrow? So
Yeah,
it's good to be back.
Lord.
Good to be back on the show.
Good to see you.
I see my people in the chat. Sinister Porpoise, Titan, the Holy Spackle. All my favorite people are here. What's going on, guys?
I have been blessed. They show up. Only one of them is here. Only one of them shows up. It's Porpoise. She's a solipsist. The rest aren't really here.
Hard solipsism, baby. I haven't heard that in a while.
Oh, it's nothing but solipsist jokes in our live chat. It's I don't know how that started, but it hasn't. And then Titan has managed to get yet one more victim to say his name. He nailed James a short while back on Modern Day Debates, and now it's yeah. There's full pranks that guy. Yeah. All right. Well, so there's a couple of things. One thing that I definitely want to mention and discuss with you is the New York Assembly Bill A6540, which would criminalize lying to a sex partner to get sex on the terms that it violates consent. So what they're saying is if you lie about your marital status or being in a relationship, if you lie about your intentions and say, "Oh, babe, I'm going to marry you. Of course, we're going to spend our lives together." If you lie about your social standing or even how much money you make, this could actually count as a criminal misconduct. So that's the Assembly Bill A6540. And then also, of course, the biggie is the Dwayne Wright shooting, in which now it looks like Kim Potter has been charged with second-degree manslaughter, and of course the biggest, George Wright, which you've been following the trial just consistently. You've been streaming on the trial as it's happening. I constantly see your updates on Twitter, like, "Oh my God, get him off the stand! Get him off the stand!" So and today that looked like there may actually even be a mistrial. So those are the three things I'd like to cover. Let's if we can maybe start with the what I think is going to be the quick and dirty, which is just the New York Assembly Bill. Could you give your background to our audience for people who don't know? So tell us a little bit about your channel, and B, who you are, your past, and how you got where you are.
My name is Nate the lawyer. The name speaks for itself. I used to be called Nate Brody. I was called MP for a while. So my name constantly evolves on the YouTube genres. But now today I am Nate the lawyer. I started my career in law enforcement. Then I became an attorney. I went to the DA's office for some time. Then I went and became a law school lecturer. So I was actually Professor Nate for about 2 years. Some of my students actually now are members of my channel, which is kind of weird. So they watch me and then they make fun of me now. So I'm a practicing attorney. As of now, I have I do more or less civil cases now. Don't really do too much criminal law stuff anymore because it doesn't pay as much as civil, unfortunately. And to be honest with you, I'm probably if I had to qualify my job description, it is a YouTuber. I'm doing YouTube full time now. My channel is Nate the Lawyer, so just put in a search and it's the first thing that comes up. And I tackle all legal topics though, so Oh no,
Just
just people could
it
just
should be. Yeah,
Google
it should be in the.
stuff.
I'll make sure it gets in the description. But I
It is
I want to
search
make a
engine optimized.
clarification. I want to make a clarification, which is I have no doubt that your students were making fun of you long before your YouTube channel. So just to get that.
That's true.
Yeah.
That's true. But no,
Right.
but I'm, it's this is the one thing about doing YouTube and being on social media now. It's fun because you get to talk to so many different people and have so many different perspectives. I've been having to block more people now because people just get dishonest. It's just because I like to have fun conversation. I don't care what your views are. I just like to understand why you believe them, and if we can, and if we can agree on like this mic, the color of the mic is black, but if you tell me it's white to try to win a point, then we can't have a conversation. You know what I mean? So that's just kind of my spiel. And I'm a very factual person, so I love facts. I get the facts wrong sometimes, but I can admit that, and I try to strive to have a more perfect conversation. That's the crux of what I like to do.
Well, that is perfect, and I think that is. Oh dear Lord. And you see, you started it with you started it with Sinister. Now she's just this is she. You know what? She acts fine when you're not around. You show up, and all of a sudden, everybody's like a comedian. All right. So, yeah, well, that's perfect because I think that's very much sort of in line with what we want to do here. It's one reason we always love having you on. So, and it's your vast experience, especially I think recently your experience as a police officer, prosecutor, and defense attorney. Well, you said you had done criminal trial, but definitely a lawyer. So let's start with what I think is I hope it's going to be the quick and easy because I don't think that's why anyone's here, but it's in the news and I think it's worth mentioning is the Assembly Bill 6540, which basically says that in order to give consent, you have to be properly informed. It has to be informed consent. And so if somebody lies to you about their relationship status, even their financial status, any of what usually is considered sort of very juvenile and hold on,
Nick, you're making it too nice. What about now?
Much better. Done. It's done. Yeah.
Okay. Sorry. I was saying, Nick, it was how you get a date on Friday night. You know what I'm saying? You go rent a car. You go, yes, I'm the Fortune 500 company. Panties go off. The next morning, you're like, hey, be quiet because my mom is in the other room. You know what I'm saying? So that's gonna knock down like 50% of the game out there.
They keeps me honest, which is saying something. I mean, that's a problem. That's a problem when they hire shepherds for our stewards for each other. All right. So okay. So I mean, has this got legs? Is it going to be enforceable? Do you think it violates any? I mean, what do you think?
Oh, well, there are a couple of things. Obviously, deception is never good, right? But to now have it to be like a criminal consent piece of it. Generally, when you're talking about the criminal law, consenting to the act under false pretenses. So, if someone's going to sleep with you, it's never. I've never had that moment where it's like, here are my qualifications. Now, give me, the sex. It's never really that type of transactional piece of it. It's more of natural. Unless you're with a prostitute, then it's like, here's the money, give me the sex, and then maybe they have a beef. So I think the law obviously is probably not going to be written in because it just criminalizes too much. It criminalizes the women who lie to you, it criminalizes the men who lie to you, and it's criminalizing just personal relationships. And you have to let people kind of just go through that, who to trust, who not to trust. I think legally, could you criminalize it and call it a non-consensual act? Possibly. But I just don't think they're going to have political will to pass it. And I do think, is there any constitutional issues with it though? I don't have a right to lie to you though, right? I don't have to have a right to deceive. But in this, and I can see how it can be good, but I can also see how it can be a stretch of the police state. So I don't know. It's just I think it's just going too far. You can't, when you start legislating people's personal conduct in that way. You can't buy a woman a drink and lie to her and tell her that you can't inflate your resume to have sex with her. Then what are we doing here? This is not America anymore. You know what I'm saying? I'm talking about like let's be honest. Who here who's been sexually active has not increased or inflated their resume to get a little booty.
To be fair, I still do it with my
Never.
wife all the time. And she's contractually required. She signed on the dotted line. She is required to stay with me. And I'm still like, oh, hon, you wouldn't believe how much money the show's making. And we got like, do you want to know who's that? Aaron, I told Aaron I'd get back to him, but I'm busy. So maybe I can do it's like, so. Oh,
yeah.
Yeah.
But you know what? I honestly think it's one of those democratic things, though, right? This is because New York's a heavily democratic state. It's like at this point, if you're policing people meeting in a bar and saying that because guys and girls both do this, right? This is not just a guy thing or a girl thing. It's just too much. I think it's just too much. But again, what can you say? We're about to talk about Minnesota, which has some of the craziest criminal laws on the planet. But if this is the worst they can do, and it's just an assembly bell, when it becomes law, then we'll deal with it.
Perfect. All right. Well, thank you for that. And I had one question in live chat, and I had forgotten to mention this earlier, which is that we are going to be, I think we're going to be splitting we're going to be splitting sort of the news and the breaking news and all that stuff off to Overtime. It's going to be on its own channel. So we already have the channel up. This is simulcasting to that channel. And so if you're chatting in either channel, the chat gets shared. So there are people in Overtime on the new channel right now. And they're sort of wondering why there's so much chat going in, even though there aren't that many people. It's because we're simulcasting to both Overtime and In Time. And we're eventually just going to move all the Overtime stuff, all the news is going to be its own channel. If you're interested in the news content, great, you got a channel there. If you're interested in the interviews and when we talk, so when we talk about philosophy and or civics or all that other stuff, the just sort of casual conversations, that's going to be In Time. And if you want both, you can subscribe to both. But anyone who is interested in Overtime and the content that we're doing right now, we'll drop a link to the Overtime channel, and you should probably go sub over there. We're not going to move it right away, but we're doing the transition, and part of that is this is simulcasting to both In Time and Overtime, and we're going to move in part because that guy there keeps busting my balls about how the content of the channel is just oh, dear Lord, he never gives you a break. He's like, Nick, you want to be better, don't you? Yeah, but really.
I got a wife back here hovering around hearing me talk about a lot of women that get booty, so I might have a problem with it later on tonight because of this first topic, right? I'm talking about lying to, when I was younger, babe. This is not last week.
Okay.
I'm about to be in trouble now.
We're recording this, right? This hasn't been demonetized. The show's still up. I'm going to clip this one. This is going to be good. This is already turning out to be one of my favorite interviews. This is going to be great. All right. So if anyone happens to know like his wife or anything and wants to send her the link, we would love to have her come in and join in on the discussion.
Yes.
So, all right. Well, someone's going to send them the first part. I'm as guilty as you are. I'm screwed. Thank God she's got better things. Yeah. All right. So let's I want to talk about before we get to the biggest one. I want to talk about the shooting of Dwayne Wright. Now, this is one. Yeah. I hear a lot of conspiracy theories. I just hit there and say, well, how could you possibly get confused? And I'm sitting there going like, yeah, but what motive does she have to actually have fired a real round off? And, it looked like it was confusing, a little scary. So this thing went off. Now it's man, as I understand, it's man 2. Now, my father was a criminal defense attorney in Massachusetts. We just had murder 1, murder 2, murder 3, and murder 2 is just, murder 3 is manslaughter. And what is this officer possibly facing, and what do you think happened, and where do you think this should go?
Well, first, just so we can know the distinction between murder and manslaughter is really about malice. They used to call it malice aforethought. And when we're talking about a manslaughter charge, especially man 2, we're talking about culpable negligence. So you're saying somebody did something that I forget the term is, what is it? It's reckless disregard, it's a conscious disregard, like a reckless act, but you're consciously disregarding something. Let me look it up. It's actually
or not willful negligence, but or maybe it is. I don't know.
Well, it's usually called gross negligence. Okay. But in Minnesota, it's actually called. It's culpable negligence, which is the same. Culpable negligence, gross negligence. So here's the standard. I have it right here. So for manslaughter in second degree, culpable negligence is when a person creates an unreasonable risk and consciously takes the chance of causing death or bodily harm. So that's what she is. That's what she's being charged with. Now, essentially, what they're saying is that this is a 26-year police veteran. So for those of you who don't know, if you're in law enforcement, every year that you're on the force or on the police force, you have to retrain every year. We call it in-service training. So every year, to keep your gun, to keep your taser, to keep your baton even, you have to recertify every year. So this officer has been through 26 of these. And this officer was actually training another officer at the time of this incident. So this officer is well trained, almost, she's retirement time in these tactics. So what they train you to do is that you take your firearm and you put it on your dominant hand side, and you take your taser and you put it on your non-dominant side. And that's because usually if you're using your firearm, you got to get to it quick and you have to respond quickly. That's deadly physical force and you respond quickly. So if you need to go there in an instant, you'd want to go there with your dominant hand. You got better control, better aim, better access, that type of thing. But for tasers, you definitely a lot of times you don't have to pull those out in such dire situations. So that's why they generally tell you put your taser on your weak hand side. From some of the stories, it seems like she had them both on the same side. She had both the taser and the gun on the dominant side. And when shit hit the fan, she pulled the gun instead of the taser. They both look, feel like pistols. When you're not looking, you pull it out and you point. But she may have, but again, that's a fact that I'm not sure about. She may have had it on her left side. And a lot of people don't understand this. In the past year, there's been many of these incidents, right, where cops have actually tried to pull tasers, but pulled their gun instead because they feel the same. They look the same. They feel the same. They don't want to look the same because usually the taser is bright yellow. But when you're fighting with somebody and you pull it, you're not looking at the taser. You're looking at the person, right? You feel like you had the taser. And that's what it looks like this cop did. She pulled the taser. She pulled her gun. And she's screaming, taser, 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 and boom, one shot, and she killed the guy. So in that instance, I think what they're saying is that for this officer having this type of experience, she should have known better. Guns are heavy, tasers, that type of thing. And since since she, maybe she put the taser on the wrong side. And if she did that, if she put the taser on the wrong side with the firearm, then she consciously disregarded the danger that may cause. So, if they're on the same side. Go ahead.
And the chief of police had said that, their policy was specifically pistol or the firearm on the dominant side and the taser on the off side. So if she had consciously put both on that does seem like a unnecessary risk. I also wanted to just going back to a previous subject. I had missed this one in the live chat, but Porpoise. Let's see, what was this? If you force people into being honest before they have sex, how will we ever have children?
That's true.
All right. Man. So you've been commenting on the Floyd. Well, and thank you very much for that because we've been having a lot of questions about it. So you've been commenting on the Floyd trial for a while, and it looks like it's wrapping up. I guess closing statements are Monday, if I understand correctly. There was some drama today because it looked like they were actually going to maybe even have a mistrial. Maybe a bullet was dodged there, maybe not. But why don't you tell us? You go on. And you had pointed this out, and I think this is very important to understand, which is especially your job here isn't be pro prosecution or pro defense. Your job is just to sort of talk about how good each person is doing with their case and what the weaknesses are and what to look for. If I understand what you're doing with your channel, you're not necessarily advocating a position. So how has this case been progressing, and what do you see when you look at the overview of the case? And we'll get into some of the details.
Well, I'm looking at legal tactics, right? Obviously I have an opinion on just based on my experience, what happened. And obviously I'm honest with people. I think this was, I think this cop was wrong. I think this was excessive. But just as a 30-foot overview, I think this has been a very interesting case for two reasons. Number one, I think it shows people now are watching testimony every day and seeing actually what happens in a courtroom. And I think a lot of people are now being exposed to that who haven't been exposed to that. And I think people really starting to see how big the advantage the state has over ordinary people, right? On one side, there's like 12 witnesses. On the other side, there's 12 lawyers. On one side, there's one lawyer. So, this is all built in, and these constitutional protections that we have are actually put in to protect us from this, from the state, and from the state's overarching power and money. The second thing I think, just with this case, is that now it gives you a peek behind the curtain in law enforcement. What are law enforcement tactics? How are they supposed to be used? And what are the responsibilities of officers when to use force? So I think both sides have been doing a good job of exposing people to it. But I think there's been high points for both the defense. There's been low points for the defense and for the prosecution. And we'll get into that in a couple of minutes, I'm assuming.
All right. So then, and then today there was something about I guess the defense was using an argument about CO2 coming into the lungs, and the prosecution wanted to rebut it. They were told they couldn't rebut it. They maybe sort of half tried to get around that, and so now the judge said possible mistrial if they try again, and I don't know I don't know where they are right now.
Well, let's dial it back first,
Okay.
just so everybody understands where we're at in the trial. Right now, both sides have put on their case, and it's going to the jury. Now, just so most people know this, but it's good to always state: the defendant has to prove nothing, right? The defendant doesn't have to put in the case. It is the state's responsibility to both put in the case and prove the charges, right? So it's the state. The state has to do that. Now, what's been happening is that the state's case is simply this: without the knee to the neck, George Floyd would be alive, right? So they're saying we can prove a felony murder. We can prove that this was an assault. This was excessive force, right? It's not justified. Excessive force, which is an assault. And since George Floyd died as a result of that assault, you have felony murder, which is 40 years in prison. The defense now has to knock down some of those theories. So, for instance, one of the things is saying that this is justified, right? This was a trained thing. So that's one of the things that the defense has put out there. Another thing is that the cause of death for George Floyd wasn't just Chauvin. It was George Floyd's bad health conditions. There were a lot of different, and one of the other things was other environmental factors. So their ME went on the stand yesterday and said that George Floyd's death was inconclusive. It may have been Chauvin, but it may not. There's all these other factors: bad heart condition, poor health, the street, and carbon dioxide. Now, this is where we get to today's mistrial. See, in the United States, you can't do trial by ambush. What does that mean? I can't, those Perry Mason moments. I don't know if I'm maybe dating myself here, but a Perry Mason moment where somebody will come in there, we got the evidence and we're changing the whole case, and everybody's so shocked that the case is won because Perry Mason brought some secret evidence to the courtroom, and it doesn't work in real court like that. Secret evidence is actually not allowed. What you have to do is you have to let the other side prepare both its witnesses and its own testimony so they can combat some of the things that are going to be presented. We want a fair trial. So in this particular case, the defense said, we're going to call an expert, and that expert prepared a report. So what happens is, generally, so everybody understands what happens is, the defendant has the right to all the evidence the state has before trial. So the state in this case said, we turned over everything we got. So the defense experts goes through it, and then they make their opinions based on the evidence. And obviously their opinions are going to be great for the defendant. So the defense experts, the medical examiner, went through it and said, well, hey, you guys didn't do the CO test. And George Floyd's face was next to a pipe, right? A tailpipe.
Exhaust pipe, yeah.
CO may have played a role. Yes. So carbon monoxide may have played a role. He's breathing in carbon monoxide. But since you guys didn't do a test, I don't know definitively, but I can add that to to maybe a possible cause of his low oxygen. Therefore, he died of all these other causes, being next to the tailpipe. So this morning, yesterday, the other Emmy, the Emmy for the prosecution, watched the testimony of this other medical examiner and said, no, we actually did that test. We did the test.
Okay, so I'm wondering if now does that that. Right. I want to try this one and see if this works. Now, this says it's not working, but let's see. I'm going to give this a second and see if. So I tried this one, and Hans Moist Thunder Nipples on the bright side. I can hear the other voices in my head now. All right, perfect.
They have sound. They have sound. Sound is back.
Perfect. I don't know how it happened, but good. Sorry about that.
All right.
So yeah, we were talking discovery. So at
the end of the day, they found the test that disproved the defense's theory that carbon monoxide may have played a role in the death, right? So they wanted to put that evidence before the jury, but it would be unfair, right? Because the prosecution, as the court found out, that the state actually had this test months ago. So if they would have turned that test over months ago to the defense's expert would have then taken it and said, "Oh, I can do a proper analysis of everything because I have the full results. So if you only give me a part of the results and just you don't give me this test, then I can't really give a full hearing. You know, I can't do my job for the defendant." So the judge said, "Okay, well, since you guys had this and you guys didn't turn it over back then, you can't just spring it on the defendant now. It would be unfair." So it said, "Well, so the judge said, well, you know, it's so unfair that even if you mention it, this is going to be a mistrial. So we're going to, you know, and at this point in time, I think since, you know, the jury is more or less sworn, that would mean the prosecution wouldn't be able to even to what's it called to
would it be double jeopardy? They couldn't retry.
So I think jeopardy would be attached. I think jeopardy may have been attached. So you know, so the witness, so the judge makes the ruling. Witnesses cannot do this, right? They cannot. This witness cannot mention this. So then, as soon as he starts testifying, he mentions it, and then that's when you had the whole thing. So then the defense attorney, obviously, he's screaming for a mistrial, but the jury really didn't understand what the hell the guy was talking about. So that's where the whole mistrial thing. So we were here thin array from the mistrial, but since it really didn't, you know, the jury really didn't know what the guy was talking about anyway. So you know, they recovered it, and now it's going back. So it was a little exciting at the time because nobody really knew what was going on. But at the end of the day, that's what happened. It was really because it was unfair to spring secret evidence on the defendant right after they closed. You know, and it was a good ruling by the judge. So. But I know we're really deep into the weeds now with this.
So was their expert still able to then posit that it might have been carbon monoxide, even though he now knows it hasn't been because they can't put that in? Or
well, yes, because now now you have the issue now is with the jury has their expert saying that it could be carbon monoxide. We know that's not true, right? That can't be accurate. It can't be carbon monoxide because now we have the actual test result. But because they didn't turn the test result over in time, they can't now recover that. So what they did was they split the baby, where there's another way that you can measure carbon monoxide in the blood, because it's either oxygen, because oxygen binds to the hemoglobin, or it's carbon monoxide. So so there's an inverse relationship when you test blood. So if you have like 90% oxygen, the most you can have is 10% carbon monoxide, you know, because they bind to the same thing. So in Floyd's case, he had 98% oxygen. So the most he could have had is, if all the rest of it was carbon monoxide, it could have been 2%. but that 2%, is well within the normal limits. So that's kind of how they try to work around it. But they actually had the test to prove that he didn't die of carbon monoxide. It didn't play a role.
Cute. This is honestly, I know this is what annoys so many people, but I honestly do really like the mind that it takes to think about how you're going to solve these kinds of problems. It's a certifiable nightmare. I also do have Nate is an awesomely cheese wizard. Nate is an awesomely knowledgeable guest. We love having him on. He's been on probably this has got to be his fourth or fifth period. And then also what was his name? Hans Moist Thunder Nipples, which I don't know whether I prefer that to Titan or not. Thank you so much for. But he was suggesting about taking off clothes. I will say this: I did have a Pornhub channel, but what I found was I got paid more money if I put my clothes back on. So I started.
Isn't it OnlyFans?
Yeah,
get OnlyFans.
Well, I have to put my
you
clothes on.
See how old he is?
Yeah.
To Pornhub.
I start. Yeah, I know. I'm apparently out of date with my jokes. They're all dad jokes now. Oh dear Lord! I apologize. My voice, as you know, my throat's been burnt. But I've managed to do a couple shows. We had to cancel Randolph, but we'll have him back. And I'm speaking again, so my wife is somewhat disappointed. But it's at least we can do shows. All right, so. Now, you had actually, just I think it was 2 days ago, you had said that there was a witness that was just getting destroyed by the prosecution. So what was the witness, and how was the prosecution so effective in dealing with this witness?
Well, the one thing is that what I decided to do for everybody to know is that I started deciding to just give like play-by-plays of the trial. So you'll notice on my Twitter feed, you think Nate is either pro-Chauvin or pro-prosecution, because when the defense does something, I take a clip and I put it on thing. Hey, this was a great cross-examination by the defense. And the prosecution, I said, this is great prosecution. So so a lot of my tweets seem one way or the other way, but if you look at my whole tweet, you're like, oh my God, this guy's all over the place. The defense, what happens is that I think the prosecution did a better job of cross-examining the defense's experts than the reverse. I think the defense didn't do as good of a job. And if you watch some of my live streams, you'll see that there was one time where the defendant was cross-examining. Now, one thing, and your father was an attorney, so he'll tell you this. And any attorney who's in the chive can tell you this. Cross-examination, the art of cross-examination, is something that most people don't understand. When a lawyer is cross-examining a witness. So this is not direct testimony. This is the opponent's witness. You're cross-examining that witness. The witness is actually not testifying. It's the attorney that's testifying. The witness is what we call a prop. You're supposed to only ask what's known as leading questions. Was it Wednesday? Yes or no? Was it this? And the witness is just supposed to give those responses. Yes, no, yes, no. Whenever the witness starts explaining something, then you've lost on cross-examination. That's generally the rule. You just want the witness. And if you look at when the prosecution was doing this cross-examinations, the witnesses were a prop. If I threw your life preserver, would you grab it? Yes. That's all you want them to do. So in that sense of understanding the goal of cross-examination, I looked at both the way the defense was cross-examining the witnesses and the prosecution. I think the prosecution did a better job. And so when you saw the one where the witness was getting destroyed, that was just because he was doing all the right tactics for cross-examination. You said, did you say Y? Did you say X? Do you say Y? And then you get to a point where one thing on cross-examination too is that you want the witness to give an answer that they don't want to give, but you want everybody to know that witness doesn't want to give the answer, right? So it's like, I like to I'm trying to figure out a good example of let's say if we have a sexual assault and the guy's his whole argument is that I wasn't there, but we know that we have, let's say a Metro card or something like that puts him, or he bought something from a store that puts him like a block from the scene. So you're going to ask him that question. Is it true you were in the corner store at 555, at 10:55? He doesn't want to say yes to that question. But if he struggles with it, like, oh, well, do you mean exactly that time? the more they struggle, the more deceptive they look. You know what I'm saying? And it's funny because witnesses don't know if you struggle or try to fight with the attorney, it just makes you look even worse. So that's what was kind of going on with the defense's witnesses. But I also think the defense did a great job in cross-examining some of the plaintiff's witnesses, some of the people's witnesses, except for I think like a couple of the experts. Because a couple of the experts, the defense just let them give speeches on cross, which was just which was disastrous.
So was there
I know the wrong answer. Sorry.
Oh no. That's a good. Well, and also, I mean, this is the kind of thing that we like. I think our audience kind of wants to understand a bit more about anyway. And I like how you brought up this. So you're supposed to ask leading questions, so questions where the answer is already implied, and they just either confirm or deny it, as opposed to on a direct examination where you can get in trouble doing that, and it's the witness that's testifying. So, were there any questions that stand out in your mind that you if you were on the jury, you would like the answer to that wasn't answered by either side?
No, I think they actually did a really great job on covering everything. I just think at the end of the day, I think as a juror, you're supposed to look at the whole case, and you would hope the jury looks at the whole case. And I think at this point in time, I think the defense is lost on the causation problem. When I mean the causation problem, for Derek Chauvin to be convicted, the jury has to find he's not the sole cause, but a substantial cause of death, right? Now, in Minnesota, there's been cases, felony murder cases like the Chauvin case, in which it's State v. Nunn, for instance. It's a case, 1980, State v. Nunn, Supreme Court of Minnesota. Look at my Twitter feed, you'll see it. And in that case, there was a burglary felony murder where two guys go break into a rich person's home. But they break into the guest house. And that guest house happens to be their servants. They see somebody in the guest house, they beat him up, and he dies of a heart attack. Now, at trial, in the Nunn case, at trial, the trial court found that the beating or the assault would not have killed the healthy person. The healthy person would have survived the assault in Nunn. But because this assault killed him, right? Because he was just because he was already ill, he had a heart attack. They found that to be felony murder. They said, well, it doesn't matter. You take the victim as they are. And that's the same thing here in the Floyd case. If you're arguing that Floyd was so sick and he was so fragile that anything would have killed him, then the defendant is not allowed to use that to say, well, he was going to die anyway. You know what I'm saying? If you rob the person of 1 second of life, you've robbed them of life, and you can be convicted of it. And so that's one of the big issues I think that I think Chauvin can't get over, is the fact that he doesn't have to be the sole cause, but just enough to say, without this, the but-for test, but for this restraint, Floyd would be alive. And I think the prosecution now from my end, the prosecution put up 5 doctors that all said that, right? Chauvin was the cause of death. Chauvin was the cause of death. Now, you would suspect the defense's expert would combat that, say, well, no, Chauvin was not the cause of death, but he didn't say that. The only thing he could say, it was an indeterminate. So really, you got, you got 5 out of 6 doctors.
So he didn't even say, no, this isn't the case. What he just said is, we don't know. He could have been. So he didn't even, okay.
It's indeterminate. So in that case, you have all the state's witnesses. You got the cardiologist, the pulmonologist, the ME, all these people saying, yes, this was it. And on the other side, you got the guy saying, well, it could have been. I'm not sure. That, I think, if you're talking about reasonable doubt. Now, when we talk about beyond a reasonable doubt, we're talking about a case in which, let's say in your most private, in your most important things in life, let's say, for instance, you get sick of cancer. I used this earlier. You're sick and you have cancer. Let's say something like that was to happen. It would be unfortunate. And you have 6 doctors. 5 of them say, you have this illness and you need this treatment. And 1 says it's inconclusive. Would a reasonable person go with the 5 doctors who all say this is the treatment, this is what you need to do? Or would you go with the one that says it's inconclusive, right? It just wouldn't be reasonable for you to go with the inconclusive doctor, right? It would be more reasonable for you to go with the overwhelming consensus. So that's kind of what we're talking about with reasonable doubt. So I think the prosecution has won on that point. I think the point that may be a little bit more contentious is the point of justification. But we'll see. We'll see.
All right. So, and I got Jake 4D for $2. Good to see Nate's lamp. Also awesome to see Nate. I think, and Mouty, who people know he's been kind of a regular on In Time, had suggested that your lamp had a beef with my $400 suit. Which, if that's true, I think we need to resolve that one, because that was I took some offense to that. Of course, who my suit gets into beef with is So we've each got our own. Although I got to tell you, part of me wants to just like, can I finally stop wearing the $400 suit? And it's just like, probably not. And the second I do, I know Agrippa's just going to be. Oh dear Lord! Oh,
yes. I'm just a t-shirt guy, so.
By the way, so just so everybody knows, we've updated the Nate's Twitter, and his channel is in the description now. So that was just completely my bad, but go check both of those out, especially when he references them. But screw you! Don't tell me how to run it. Dude, this is my. You want to run things? You go back to your little however many hundreds of thousands of subs you got now. You go do that. This is my neck of the woods. I get to run things. If the $400 lamp and they say, okay, so I thought only Kyle had $400 suits. Yeah, okay. So I think some of them are a little they're catching up. Okay, so now it sounds. Please.
Mm-hmm. But one thing I do want to bring it back to the Floyd case, because I'm sorry if I'm doing a lot of teaching, but I know there's going to be a lot of concepts here that I have to kind of explain out, because I know a lot of people just have never been exposed to them. So one of the big issues in this case that's going to come down to is, was this justified? Was Derek Chauvin justified in this use of force? And the defense has put up the excuse, or the defense, that this was justified because George Floyd was a threat. He was a risk. There was a risk because if you watch the trial, you would have heard a lot of times the defense make the claim that someone who's passed out could wake up and be a threat again to the officer. And that seems to be their thing, that when Derek Chauvin had his knee on his neck and he passed out, they held him there because he was a risk to harm the officer, even though he was handcuffed. But a lot of people don't understand is that in law enforcement, you can't use force, or you can't use force to prevent risk. You can only use force to prevent threats. And let me explain what I mean. If I, as an officer, go to a scene and there are three men, that's a risk, right? That's a risk to me, because I'm only one officer and there's three people. That's a risk. And when you have I can't, because there are three people there, that's a risk. I can't then just pull out my firearm and tell them, get down, right? That's unreasonable, right? Because even though they're a risk, they're not a threat. If they had weapons, if they went to a fighting stance, they are now threats. And I can respond to those threats differently. But just because there are three guys there, that's a risk, but I can't respond to that risk with force. And that's kind of the same thing that's happening with the George Floyd case, is that George Floyd, yes, when he was handcuffed and he was resisting, he was a threat. He was resisting arrest early. But when he stopped resisting and was just laying there, you can't now continue to use the same amount of force to prevent that risk. He's a risk to do harm. He's a risk to do this. And that's the thing that generally convicts cops, is because cops respond to risk with force instead of responding to threats with force. And you'll see a lot of those things that happen in these cases, where a cop will overreach and say, well, I believe this guy, I was scared for my life. That's responding to a risk and not responding to an actual threat.
So he was ostensibly, at least if I understand this, he in fact was, could be considered a threat early on, but once he was cuffed, once he was subdued, you can't argue that he's the same level of threat, so you have to reduce the force, because now it's no longer a risk. It is now a more, you may feel threatened, but it's not. I'm sorry. I think I reversed that. He's a risk now, but he's not a threat.
Okay. And obviously somebody handcuffed is not as big of a risk to anyone, right? He can kick a little bit, but even though he's still on the floor, and if the force being used to subdue him, the way the law works that everyone has to understand is that cops aren't allowed to use any force. They can only use the minimum amount of force to gain control. So I can only use enough force to overcome your force, and the state gives us that authority. But the state doesn't give you authority to use more to use overwhelming force, and that's where you're starting to get into it. Here is that here did they use the minimal amount of force to overcome whatever resistance Mr. Floyd was using? I would say in the first couple of minutes when Floyd was resisting, right, when he was resisting, he didn't want to get into a car. They were permitted to use force to overcome that, right? Because he's being arrested. People don't like to get arrested. But when he becomes unresponsive, when he has no pulse, when people are like, he's not moving, he's not breathing, then if you use that amount of force to subdue him, you can't continue to use that force even when he's not resisting, right? Because that force was good when he's resisting. It's not good when he's not resisting. And the law demands that police officers reduce the level of force, because the level of force that you use as an officer is dependent upon the suspect's reaction. So, for instance, if you go to a bank robbery and you're in the middle of a shootout, the suspect throws his gun down and put up his hands, you're not allowed to just continue to execute. You can't just continue to fire with him. You have to then, lower your level of force and go arrest that person. So that's the way it works. It sounds simple in concept, but when you're in the heat of battle, it gets really, really tricky.
Well, and when if you err in that, you could end up dead. I have to believe that,
Yeah.
You have a strong motive to err on the side of caution for your own physical safety as opposed to that of a suspect. So you had said something on one of your recent streams that I really liked. You were talking about, so you just mentioned now about a police officer and what they're empowered to do. So my question is, if a police officer kills someone, one of the things that you said is that it still is, of course, it's a killing. They've now killed someone, and the question becomes, is it justified? And that's sort of where, so officers are actually empowered to kill under certain circumstances where it is justified by their position and the demands of the job. Could you speak about that a little bit?
All right. Well, officers, we all know officers have to use force to do their job, right? They have to arrest people. And in arresting someone, sometimes they have to use force. If I put handcuffs on somebody, if you're a regular citizen and put handcuffs on somebody, you've just assaulted them, you've probably committed false imprisonment and maybe even kidnapping, right? But as an officer, you are under color of law. The law gives you the right to effectuate these arrests. So understanding that concept is that as an officer, officers are permitted to commit what I like to call legal assaults, legal batteries, and legal murders.
That was right? It. Yep, it was. Yeah. So it's assault and it's battery, but it's legal. Yes. Okay. Thank you.
Yes, it's all legal. So in this case, in the Chauvin case, Chauvin technically committed an assault, right? If he wasn't an officer and these are just four guys, that would technically be an assault. But because he's an officer, he's effectuating an arrest, he can commit that assault. But the law makes it very clear that officers are only permitted to commit these lawful assaults, and even lawful murders, as long as it's reasonable based on the situation, based on what a reasonable officer would do in that situation. How would you know what a reasonable officer does? You look at their training and protocols and so forth. So at this point in time, Chauvin was, at the beginning, when they threw him to the ground, when he was resisting, that's an assault, but that's justified in the situation. But now that assault becomes if the officer doesn't reduce the level of force they use, just like remember with the bank robbery incident where you run to a bank robber, the guy throws the gun down and puts his hand up. If the officer fires at that point in time, then that's not a justified murder. That's not justified because the law demands that you be reasonable in your use of force, only using the minimal amount of force to overcome the resistance. So if someone's not resisting, then you can't use force technically. And that's where the Derek Chauvin issue comes in, because when he's passed out with no pulse and not breathing, he's not resisting at all, right? So if someone's passed out, you can't continue to use force on a dead body. And that's essentially what happened with the Derek Chauvin case, and that's what officers, unfortunately, it's a very thin line, but I know at the academy we used to train. This is the closest you'll be to jail, because if you make a mistake, you can go to jail. If someone else makes a mistake, they lose their job. You'll just be you're happy if that's the worst thing that happens to you. And to a certain extent, I like this cop in the other cop that in Minnesota, the one that shot the kid. She made a mistake. You could tell by the thing she made a mistake, but that mistake just cost her her freedom.
Well, and you could tell too. She did warn that she would do it, and then she followed the proper procedure. But it's. And I do have, I mean, I've never been a police officer. I've never been in a situation like that. But I have empathy for the idea that, you've reached for the wrong. And if she had them both on the same side, I think obviously she's going to have consequences for that. But
that's the conscious disregard. There you go.
Yep. Yep. Well, it's you work in social media, so you know too. It's just like there's a lot of vitriol too. It's like, oh, I see, baby, you shouldn't have female cops. It's like, are you fucking shitting me?
What? Yeah.
Oh dear Lord, it's just like I'm getting much better about it, but it's still every now and then I'm just tempted to just go on Twitter and like rage on. Okay, Nick, chill. So
yeah. Go ahead.
No, you please.
No, but I was like, Twitter's a cesspool, but I love talking to people on Twitter. But my only problem is that when people start just becoming dishonest, like I was talking to some guy earlier today about the Capitol Hill riots, and you remember, and Ashley Babbitt, who was shot during the Capitol Hill riots. For those of you who don't know, that was the woman who the Congress people were barricaded behind this door, and they were trying to evacuate the building, and there were armed guards in front of the door with their guns pointed to the door, saying, "Stop! Get back! Don't!" And she broke the window and it jumped to try to get through to the secure area, and the cops shot her. Right? She's coming through. They shot her. Justified shooting, and so the Justice Department comes down, justified shooting. When I first looked at it, justified shooting. There's no way that shoot is not justified. You're in the middle of an alleged insurrection, right? You're in the middle of a mob, and you're trying to break into a secure area where the VIPs are. So one guy was like, "Oh well, the people who were in that hallway weren't part of the mob." That's somebody I got to block. You know what I'm saying? That person just looking for any excuse to say. And it's funny because now the problem is now, I have a lot of people who follow me who I've just asked Ashley, because they were saying Ashley Babbitt, for instance, was unarmed. So I made the point. I was like, well, Ashley Babbitt was unarmed, and now my right-wing conservative friends, they seem to have a problem with police shooting unarmed people or killing unarmed people, but George Floyd was unarmed and handcuffed and died, right? He was not only unarmed, he was handcuffed, but his was justified. But shooting this woman who's running, who's literally, that could have been suicide by cop for all we know. When the cops point the gun at you and they say stop or shoot, she chose shoot. She didn't stop. She chose shoot. She was like, I'm going to choose shoot. Didn't believe them, and they shot her. So that's what, so I think now things are just so political that you got to just look at this thing for what it is, right? Ashley Babbitt, she, unfortunate, but that cop was justified. I think the Jacob Blake, for instance, who happened to be a black guy who, with the knife and stealing the kids, everybody, they stopped NBA games after that shooting. That shooting was justified. And I think if we look at every incident as it is and on its own, then I think we all come to the same conclusions. But I think right now we're looking at it from the spear of racism. Like even in this recent case in Minnesota, unfortunate to say, but this kid had felony warrants, right? And he was resisting arrest. Now, that doesn't mean he should have died. That doesn't mean this cop should use bad tactics. That just means he should have been tased and then put to jail. And you probably never heard of this guy again. But the fact that, this officer made this mistake has now made this kid a martyr, and I think the lesson that we failed to realize in all of these cases, there's one thing true about George Floyd, Jacob Blake, Ashley Babbitt, and this guy Wright. They were all resisting arrest. Police were giving them commands. They resisted, and unfortunately, they passed away. Each one of them. Ashley Babbitt, they were saying, "Stop or we'll shoot." She chose shot. I think if you think about that, if we're talking about a chain of causation of events, if we stop resisting, then I think none of these people die. But no one's looking at that. We're looking past that and saying it's the cops' fault instead of putting some blame on. Hey, listen, the cops were put in a position to respond. They should have responded better. They should have responded lawfully. But why put the cops in that position to make the mistake? You know what I mean?
Well, and that's actually we said that like last week, and I think that was an important. So one of the things that we had spoken about was that. What was it? I'm losing my train of thought. Two things. I mean, first of all, I remember now. So in a lot of these cases, they think that the police or officers are doing something they shouldn't be doing. Usually they're wrong. Usually they're not aware of the law or nuances in the law. There was a shooting of a white 17-year-old kid that we aired a while back. It started with the kid saying, "I want to see your badge." And the officer said, "I'm not going to show you my badge." The kid said, "No, you have to show me your badge." He goes, "No, I don't have to show you my badge. I have to tell you my number. If you ask for my number, I have to tell you, but I don't have to show. I cannot show you my badge." Now, I don't know how or why the details of that, but to the best of my understanding, the officer was telling the truth. Now, the kid was just like, "No, you have to show me your badge." I was like, okay, the kid's seen a little too much TV. This was a 17-year-old kid on his way to his girlfriend's house, and he was shot and killed. Now, it's sort of like if the officer is doing something they should not be doing, which is hard to tell unless you're a lawyer. If they're doing something they shouldn't be doing, that exact moment is not the time to call bullshit on them. It is not the time to get into an argument over it. It's something that hopefully you can deal with later, but if they really are bad cops and if they're doing something bad, you're just going to make it worse by engaging with them there in the first place. Under any and all circumstances, once you're being arrested, there's only one thing you should do, and that's not fight, not resist arrest, and deal with these things. Comply. Just do what you're told. And again, and I think you said it, and this cannot be said enough, which is this does not mean that any of these people deserve what they got. But you do, if you're going to fight with 3 or 4 officers, the chances that somebody's going to get hurt. And he jumped into a moving car, so somebody could have been, one of the officers could have been sucked under the wheel of that car as he was trying to get it started. He could have been sucked in under his own car, or he could have gotten away. But then what would he have done? So it's one of those things. There's no benefit and nothing but downside to resisting arrest, whether it's legit or not. I don't care. If they want to arrest you,
survive the encounter.
Yep, make it through, and then deal with whatever problems are. But one thing at a time. So Jake 4D, $5, and then there's one other. Let me hit Jake. Slightly off topic. In Nate's opinion, is qualified immediately overused or overreaching in general, or is someone likely, or is it someone like a? I think there may be a typo. I'm having a hard. Can you see that, chat? I'm having a hard time.
Slightly off topic. Nate's opinion is qualified, immediately overused, or overreaching in general, or is it someone like a generally good standard? I'm not sure if I'm not sure if I'm understanding.
Okay. Qualified.
Are we talking about qualified immunity? Because qualified immunity overused. I'm assuming this is qualified immunity. It's about qualified immunity.
Oh yeah, okay.
Qualified immunity. For those of you who don't know, I'm assuming everybody knows it, but just to let everybody know, qualified immunity is the concept in which if you are a public official and you're working for the state and you do something bad, you hurt somebody or something, they can't sue you. They sue the state, right? So you are personally kind of immune from personal liability, but the person can actually sue your boss, the state, right? It's just like if I work for McDonald's, you can, no, you're not going to sue me. You're going to sue McDonald's because I got no money, but McDonald's has all the money. So that's why, except in the McDonald's scenario, you can sue me and McDonald's, where if you're a cop, you can't sue the cop. You can only sue the state. So I think qualified immunity is overused. But I think it's interesting because I don't think the cops, let's say if you were to sue the cop, if you got hurt by a cop, that's not who you're getting all your money from anyway, right? It's the state, it's the city. Those are the people who you want to sue because those are the people who got deep pockets. The cop is working a 9 to 5 like you. You know what I'm saying? So his pockets aren't really that deep. So I see it on both sides. I see on one side it's it's a nice tool to maybe deter cops from doing certain things. But then I see on the other side, it's really just it seems to be unnecessary because you're not really going to sue the cop anyway. You're going to sue for the big bucks anyway. So, but I think some form of qualified immunity is necessary because but it all depends on to what level. I think the law, the way it's enacted now, the way it's observed in the courts now, it needs to be refined. But hopefully Justice Thomas, like he said, they want to revisit it. Because I do think it's just too broad nowadays. But we'll see. We'll see.
All right. So one last one I wanted to ask you about, just because we touched on something very close to it anyway, which is what to do when the situation changes, and how rapidly. And this is it seems to me like things change very quickly, and you're going to instinctively want to err on the side of protecting yourself. Have you been following what's been going on with Adam Toledo? Because he was shot and killed. I think it was I want to say in the Chicago area. Yep, it was Chicago. He was shot and killed, and he was a 13-year-old kid. Now, the officer said that he had a gun. I saw that, yeah. Yeah, initially it looked like he might have had something, but they couldn't tell. But at the moment that he was shot, he had put up his hands and he had nothing. Right after being shot, the body camera does show the officer looking around the area and finding what appears to be a discarded firearm. So it appears like the officer's initial report was accurate, that he had in fact seen a gun and that the kid did have it. The kid discarded it and just threw it, hands up, and then was shot. So it seems to me that this is an example of what you were discussing, and I was curious if you had any. There's footage of it, which is unfortunately difficult. But it sounds like that's what you're talking about. Not, the officer did his best to resuscitate. Yeah, but
I wasn't talking about that particular story. That's just an example I was using. But in that story too, it's all tragic. But I want people to put themselves in this role and think about this. And again, you're going to judge this officer in this way. You got somebody with the gun. You're chasing that person, right? Your gun is out. Number one, you've probably been, you're like 2 donuts away from obese. You're thinking about family. You got all this equipment on, bulletproof vests and all that crap, and you're chasing this person down. Now, eventually the person does comply. But it's all in the moment, right? The person throws the gun away, you don't see the gun, and the person turns and puts their hands up, and you fire. Those moment-to-moment transactions, I just don't know enough about this to make a judgment call. Because if someone turns around and puts their hands up, I don't know if this cop was still thinking he had the gun. I don't know if the cops saw him drop the gun. I don't know. Like the scenario, it could be a bang bang where it's just like, boom, boom, because he's scared. It could be something where the guy put his hands up, the cops, I just don't know. But I can see something like this going either way, in the sense of if it's something that's just very quick, then I can see the cop being justified in the risk assessment where I thought he had a gun and when he turned, I thought he was turning with the gun. Or I also could think the second piece of it, where if the body cam shows that he was running and the cop puts his hands up and turns around and the cop has enough time to respond and you can clearly see this guy's hands are up, then that cop is going to jail. So I would need to see more about it, but it's one of those cases where I can see something like that going either way. But I would always, I'm at this point, I would err on the side of the videotape. If the videotape shows someone with their hands up being shot, that's a problem. That cop's got to answer for it.
Yeah, it was about a second, and what it looks like is the kids. He's going through a gap in the fence. It kind of goes through, and he appeared to have something right before he went through. Then he turns around with his hands up and is shot about a second later, which implies to me that the officer was already considering pulling the trigger. And just as soon as the kid turned around, the officer pulled the trigger before he could process the fact that the hands were empty, is what it looked like. I'm not an expert, but that's what it looked like. And what they found was right behind that spot on the fence was the pistol. So it looks like he dumped it so they're expecting riots in Chicago tonight as a result, because the body cam footage just came out. Yeah.
And it's yeah, no matter how many other people are killed, is as soon as a cop kills somebody, it's going to be. But one thing I would say also too is that understand how to judge these incidents and how the law judges these incidents, because that's the one thing I like to train people on. The law is going to judge this incident not by what this cop's intentions were, not with what he knew. And I like to give the example of the bank robbery again. Let's say I'm a cop and I'm going to a bank robbery and I intend to kill the bank robbers, right? I go in and I'm on camera. I'm like, I'm going to go there and kill bank robbers. And then when we get there, we have a shootout. The bank robbers shoot at me, I shoot at them, and I kill them. The prosecutor then says, I'm going to charge Nate with murder because he intended to go to that bank robbery and kill those bank robbers. I would be found, the law would not allow me to be prosecuted because it would ask the question, would a reasonable officer, not what my intentions were, but would a reasonable officer facing the same set of circumstances had acted in the same way? Bank robbers shooting at you, I'm shooting back, I shot them and killed them, then the law would not allow me to be prosecuted for that. So that's an extreme example, but that's how it is going to be in this case. With a reasonable officer facing the same set of circumstances without the benefit of 20/20 hindsight, without the benefit of knowing that he threw the gun away, right? What did that officer know at that time? Not his intentions, but what did he know? And what a reasonable officer with his knowledge base had acted the same way. And that is, and they give you some factors to look at to understand how, what was the nature of the call. Are we going to a bank robbery? Or are we going to a counterfeit? Or are we going to a cat stuck in a tree? Because that lets you know the risk level. Then then whether the person is resisting arrest. This person happened to be running away, right? And then was the person a serious threat to the officer or other people? Here, if the suspect may have had a gun, that may change the analysis. When the suspect didn't have the gun, then did the officer have reason to know that there was no longer a firearm? So that's what I'm saying. A lot of these incidents, until you have all the information, it's really hard to make a call because the law is very specific and understanding how to judge these officers in this situation. It's not my personal standard. This is a constitutional standard that's being used in a Floyd case. It's going to be used in the Wright case. It's going to be used in every use of force case here in the United States. That's the standard.
All right, so that goes
Graham v.
perfectly
Connor
to
for you legal nerds out there. The case is called Graham v. Connor for the legal nerds out there. Sorry.
No, perfect. That goes to my I think my last question here is, and I've often heard that for police, it's basically what the life of a cop is, because you said the donuts. So the life of a cop, day after day of boredom, paperwork, you're just walking around and you're just looking for stuff, followed by moments of abject terror, and then back to the boredom again. So you didn't say what would a reasonable person do. You said what would a reasonable cop do? What would a reasonable officer do?
Yes.
So you're facing a jury of 12 people. Presumably none of them are officers, so none of them have any idea. They might know what they would do, being ostensibly reasonable people, but the standard isn't a reasonable person. It's a reasonable cop, and none of these people have spent a day in an officer's shoes. So the question I want to ask you is, if you're an attorney on either side, and you're trying to get it into their heads what's reasonable for a cop, what do you try to do?
Well, simple. A reasonable officer will follow the policies of their department, right? Because the way it works is that you have the law, Graham v. Connor, right? Most cops have never heard of that case. Most cops, when they go to trial, they'd be like, oh, there's a case called Graham v. Connor, and that's how they're going to judge me. They don't know that. Graham v. Connor, those constitutional principles are interpreted by the locality, and they're put into policies and use of force policies that the officers follow. So, for instance, the officer, and those policies have things like what they call officer subject factors. When you go to a scene, a reasonable officer will take things into account. How many suspects are there? Is there a weapon involved? Is the person resisting arrest? What's the nature of the call? Is the person threatening people? Those type of things. And you're taking all that information in and then making a judgment call about how to respond. So the jury is actually trained to understand what the policies of that department are. And if the officer followed those policies, then that officer would be justified. So that's what we're finding out in a couple of these cases, like the case with the taser, for instance. If the officer followed the policy and her taser was on her left side, and she just mistakenly grabbed her gun on her right side, then I think that officer could be found to be justified in her actions, right? Even because it was just a mistake. She didn't consciously disregard. She wasn't reckless in what she was doing. She just made a mistake. But the state will still have to pay this person money because this was this killing was negligent, but it would, you don't have
like a
criminal
death,
negligence standard. Yeah, you don't have criminal stuff. But let's say the situation changes just a little bit where she now puts her taser on the same side as her gun. Well, that's a violation of policy, and a reasonable officer would follow policy. So what I would do is I would have her training officer. Do you train officers to put the taser on the same side as the gun? No. She wasn't she's not being reasonable because reasonable officers follow their policy. She didn't follow the policy. Therefore, she shouldn't be, this was unjustified in that sense. But again, I don't know if those facts are true, but I'm just using it as a demonstrative purpose.
Perfect. All right. Well, Nate, it has been a genuine pleasure. Thank you so much for joining us and letting us know. I think anybody, if you want to see, I have to believe you're going to be covering the closing arguments, and then it's going to be
yes,
however long the wait is.
We got 40 people watching. I want to say hello to everybody.
That's 40 on one channel. I don't know how many is on the other. Probably a lot less because we're still sort of moving over. But thank you all for joining us. And please, if you made it this far, I steal my lines from Nate. So I watch his shows and was like, that's a good line. If you made it this far, you liked the show, please like and subscribe. It's a great way to help the channel out. And, and we've got, oh my God, we've got Neil 604 next week. We've got, he's going to be coming on just to hang, actually. Where we did his deconversion story, but we're going to hang. We're going to cover, Tart's going to be on too for a discussion, and we just had Carrier, so there was one other, but you know what? I'm tired, so I'm gonna move this along. I will say, it looks like because the body cam footage on the Toledo shooting just came out, and people were very upset. The kid clearly did have both arms up, but it was a quick thing. So we're going to see what happens with that, and if it ends up turning into a large situation, we'll probably cover it. If not, we'll let it go. But you can stick with us, and if we cover it, we may show the footage later tonight. But it's something I think I'm not going to show right here with Nate here. We'll just you've seen it, but it's a different.
You don't want to demonetize the video.
yeah. We'll keep it for. I mean, we demonetize all our breaking news ones anyway. I just naturally assume that they're demonetized going forward because when you're carrying riots, anything can happen. But thank you again, Nate, for joining us. Thank you, everybody in the live chat.
Thanks for having me.
Oh, my pleasure. I normally hang out and if you have a few minutes and you want to join us in the Discord and say hi, I think there's some other questions for people in the Lounge VC who would love to ask you questions. I normally join, but I'm going to try to rest my voice so that I can still chat. But so if you want to do that afterwards, I think you're on the Discord. So thank you all for joining us, and I look forward to catching you all later. Have a good evening.
Take care, everyone.